Pitfall number 2, doing it yourself. I wish I could see a show of hands from people attending what I just said about, putting a special kind of trust in your will. If you have a do-it-yourself, an online plan, a prepackaged plan that you got on the internet, I'm going to bet that it does not have a type of trust within your will that is created on the person's death, and it creates this trust for the disabled person, or it creates the possibility of a trust should somebody who's not disabled now become disabled later. See, estate planning is all about planning for, yes, the here and now, but the future. What happens if somebody becomes disabled? What happens if they need long-term care, if they need government benefits? What happens upon their death? What happens if a beneficiary needs special protection and help? The likelihood is that any kind of do-it-yourself option that's available to you, free or for a nominal cost, is not going to incorporate those protections. So people can be complicated, their situations are complicated. An online form, do-it-yourself form, is not likely to really address what your situation is. Now, you may be somebody, and I hear it quite a lot, that says, I just want a simple will. And I totally get that. They're not saying I don't want a will that doesn't fit my situation. They're saying I don't want to overcomplicate things. I don't believe my life is complicated. I want to understand it. So at ELG Estate Planning, we make sure that your will is the right one for you. Now, the likelihood is it is going to contain trusts. For example, even if none of your kids have a disability, we're going to put in it what's called a contingent supplemental needs trust. In the event that somebody is disabled when you die, then their share is going to go into that trust that is created through your will, through probate. You heard me say probate, on your death. And in the event that nobody needs that kind of a trust, then it's just going to go 1/3, 1/3, 1/3. But what if one of your children, same scenario, mom dies, adult children, that one of her children died too, such that they left 2 grandkids of the mom, who's actually the grandmother in my scenario. Then what happens when she dies? Mom dies, her child dies, her adult child, and then there's these 2 minor children. There needs to be a trust for the grandkids, because under what's going to happen with the distribution is it has to go to the minors. Minors can't hold money. There has to be a trust, and there needs to be a trustee. So the will contain a grandchildren's trust in the event that one of the 3 adult children dies, leaving their children. So there's a lot of scenarios where we're going to include in your will a trust. And from an online form, I think that it'd be very difficult either to create it, but if you do have those options and you are doing it yourself, make sure that you have a grandchildren's trust and a contingent supplemental needs trust, which, by the way, I've never seen in an online form. So keep in mind, and I'm talking about the state of Washington, everything that we just talked about can also be accomplished through a revocable living trust. A revocable living trust is often a preferred option because it avoids probate if done correctly. So you might be seeking to do a revocable living trust online. If you are, you will notice that part of that package contains a pour-over will. What is a pour-over will? A pour-over will is included with a revocable living trust because If the revocable living trust is not properly funded, which is getting to the next topic, then there needs to be a will because there will be a probate as well. So we'll talk about that in a moment. But getting back to pitfall number 2, doing it yourself, the problem basically is that you don't know what you don't know. You don't know what should be in your will or your trust, and you don't know which is the proper platform to use, a will or a trust. If you're in the state of Washington, and we'll get into this in a little while, and you want to protect assets, let's say you're married, and let's say you are concerned about long-term care costs because you and your spouse are retired, and you want to make sure that you leave your spouse with something, they don't become impoverished, that long-term care costs don't eat up all of your assets, all of your estate, then you're going to want to have a will that has a particular kind of trust in it. Now, how would you know that? How would you know that from a form? You don't. And that's what I'm saying, is that estate planning is not just a set of documents, it's the guidance, it's the counsel, it's working with an attorney you trust to give you that confidence that you know you have the right plan in place, the right documents, but the right plan as well. So estate planning, another thing I would say about it is that your estate plan often is not tested until something happens, until you become disabled, until you die. If it's not tested until those things happen and you've left it to chance, you've done your own templates, do you know, was it the right estate plan? And you might say, I'm dead. I don't know. I don't care. But think about the people that you prepared the estate plan for. It's not just for yourself, but it's for your loved ones. It's for your family. And did you leave them a gift, or did you leave them a burden because it is a bad plan and now they have to fix it? And fixing anything in law means lots of legal costs. Way I would say that making an investment in an estate plan, the gift that you give to the family so it's easy when you're gone, that's something that our clients often say that's really important to them.